Hello and welcome to Minnesota Landlord Forums, where we empower Minnesota landlords and property managers with on-demand DIY forums and how-to videos. We launched in December 2024. Today's lesson video, Minnesota Legislative 2024 Update. We will cover the Omnibus Bill of May 2024. That was very extensive. Most of its content is effective January 1, 2025. Except for a couple of the provisions. Note, none of this is legal advice, and my name is Bradley M. Schaeppi. Today's content will be very dense, a lot of material. Feel free to stop and pause as you wish to understand, and you'll also see forms that will be available via subscription and single purchase with videos on minnesotalandlordforums.com when we launch. All right, let's get to it. Lots of sections in today's video. The first section is abandonment definitions and mitigation of damages. 2, tenant right to organize. 3, expanded tenant retaliation rights. 4, pet fee prohibition lease disclosure. 5, individual taxpayer rental application language. 6, construction delay and occupancy. 7, common area landlord covenant. 8, rental application eviction denial restrictions. 9, late fees for housing assistance payments. 10, condemnation update. 11, mental health or health crisis updates. A victim of violence update. And lastly, eviction service and notice updates. We'll not cover it today, but a lot of these new sections also come with significant new civil penalties for violation. All right, let's get down and right into it. Our first section today is residential tenant abandonment. So what the legislature did is it created first new defined terms in 504B 001, which is referenced up here and on the top here. 2 new terms, abandonment of tenancy and abandonment of personal property. I'll read it briefly. Abandonment of tenancy, intentional and voluntary absolute relinquishment of premises by the residential tenant. And abandonment of personal property of resident leaving some of the tenant's personal property on the premises after permanently vacating the property. Well, prior to today, there was no statutory definition of what abandonment meant. It was referenced in the statute and it was generally understood. But there's now new specific terms that control this. And these definitions are tied to a new section, 504B 154, that talks about what happens if a tenant meets that specific defined language. So if the tenant abandons, remember, we got to tie back to the specific language that we referenced earlier. During the lease term, landlord shall make reasonable efforts to rent at fair value. If a new lease is signed, it terminates the old lease, and the old lease terminates on the date landlord has notice of abandonment if the landlord fails to use reasonable efforts to rent at fair rental value, or the landlord accepts notice of abandonment as surrender. And what surrender typically means is to end the tenancy. So that's key legal language that's very new to residential landlord-tenant law in terms of this day-to-day practice. It's much more familiar to commercial landlords with office and industrial. They'd be more familiar as the term surrender of premises is typically in a lease. And furthermore, the tenant will be not liable for rent after termination of the tenancy. It cannot be waived. And if a lease is periodic at will, basically month to month, the max rent liability is 1 notice period. And so the practice tip is this is going to be very new, uncharted waters for a lot of management companies and landlords. So what this means is the whole concept of, lease break fees, and you have to pay so many months if you want to break your lease, all of that goes by the wayside. This statute now controls what happens if a tenant even wants to leave month 4 of a 12-month lease. It doesn't say specifically that the tenant can terminate the lease, but effectively it penalizes the landlord if they don't take specific actions to release the property. That's why it also can be called mitigate damages, which again is more common in commercial leases. And so lastly, I also want to refer to this accept notice of abandonment as surrender, which means is that what's going on is the tenant is leaving, vacating, so they are giving up their rights to possess, but you still have a valid lease that requires rental payment even though they're not there, unless of course the landlord surrenders that. So it's going to be key the language that's used to communicate back to the tenant upon this abandonment. So I have created for Minnesota landlord forms 2 specific forms. One is titled the Minnesota Tenant Non-Abandonment and Landlord Non-Acceptance of Surrender, meaning the landlord saying, no, you haven't met the clear standard of abandonment. Maybe there's a bed there, maybe they haven't turned in their keys, but from a factual perspective, a landlord is making the determination there's no abandonment, and no, we're not accepting this as surrender. The flip side of that is the landlord acknowledges the abandonment. So this one is Minnesota Tenant Abandonment and Landlord Non-Acceptance of Surrender. Again, you're clicking the box saying yes. Let's say everything is gone, all the keys are turned in, and they've just left, but they still have, let's say, multiple months left on the lease. It's also communicating back to the tenant, no, we don't accept your surrender of the premises. That key language ties into the statute versus saying if the tenancy terminates completely, you have to be careful because you're going to be turning the clock off of rent that may be due from that tenant. All sorts of other things go into play as well, because since the tenancy hasn't terminated, you're not providing a security deposit withholding letter yet because you have a valid tenancy. All right, so we're going to move on to 504B.001, which is our definition section, the tenant right to organize. So again, we have new defined terms in the key landlord-tenant statute 504B. They've created a new term called tenant association and a tenant organizer. We're not going to get too much into the weeds here, but effectively it allows these associations and the organizers rights at the property to talk to one another, to actually contract on behalf of other tenants, but also understand these are very specific defined terms. And so it's important to follow up specifically on this. And here's a good example of these new rights. First, the new tenant association rights allow this new concept of a tenant association, which addresses the issues related to the living environment, the terms and conditions of the tenancy, and specifically owners must allow them to conduct their activities related to the establishment and the organization. And there was a list of items that they can do. Common area leaflet, including boards, distribute to individual units, initiate communication, including survey for interest in the tenant association, and convene building meetings in the building. And so here's an additional language. The landlord is not required to provide any tenant contact information. The tenant association must adopt bylaws or an operating agreement, and the tenant association must be completely independent of the owner's management and representatives. And management may not attend unless they're invited. In the tenant organizer, if it's not a residential tenant, then the organizer must be accompanied in a building by a residential tenant who resides in the building. So if someone is not a tenant and they say, I'm a tenant organizer, and they're alone, they can't be in your building. And so the landlord prohibitions, there can be no rule on peacefully organize, assemble, canvass, leaflet, or exercise free expression. No prior permission on protected activities, so they don't need advance written permission to do those things. And no unreasonable rules on time, place, and manner. So the flip side of that last provision is they're taking this term from lots of other areas of law, but effectively you can have reasonable rules on time, place, and manner, meaning there's a common area room, what times they can do these things. But again, I would err on the side of reasonable. All right, so retaliation prohibitions. 504B.212. So there's new language. For those of you who have been around a long time, there have always been retaliation defenses to evictions. And so now there's additional new language that refers to what the landlord, additional retaliation provision, and I'll read it out here. The landlord may not increase rent, decrease services, alter a lease, file legal action against tenant, contact law enforcement on immigration status, or seek to recover possession or threaten action in whole or part in retaliation after the tenant reports the code, building, house safety violation, requests repairs or enforces the lease, joins a tenant association, or testifies in court. So understand that on most occasions, this is relatively straightforward protections for tenants. However, understand that if there's a bad faith tenant abusing this, a practice tip is a management company or landlord should consider breach of lease notices for false reporting. And that would require, obviously, let's say they're complaining of a safety violation that doesn't exist. You'd have to go in and document the lack of evidence and then follow up with that breach, for example. Here is an example of a form from Minnesota Landlord Forms. A specific breach of lease can be used and modified in many different ways. We'll move on for now. Okay, so new 504B11 pet policy fee prohibition lease disclosure. Effectively, there's new language in this 504B113 subdivision 3, which basically says if there's a pet policy, so if the building and management allows pets, then the landlord, and there's a fee for that pet, the landlord must disclose in the lease that they're prohibited from a pet fee charge or deposit for service or support animals. So the practice tip is just use a compliant lease. As of January 1, you're going to need this language in your lease. And so what I suggest is if there's already pet language and a pet addendum, then considering this added disclosure and putting it right there. Or it can just be in your base lease as well. In Minnesota Landlord Forms, we have it baked into our base leases for Minneapolis and our statewide Minnesota base lease. Here's one example of the Minneapolis lease that we have for Minnesota Landlord Forms. And note as well, we break them down in different types of leases for single family, duplex, triplex, fourplex, and townhome condo. All right, Minneapolis. Okay, another new provision, 504B11. We'll go to the top right here. The landlord must provide on the rental application the option for a prospective tenant to submit an individual taxpayer identification number or social security number as follows: SSN or ITIN blank. That's it. The statute is very descriptive of what needs to be there. So, and also the landlord must not deny the rental app solely because the prospective tenant provided this ITIN number and not social security. So a few practice tips. If there's obviously only an ITIN number, it may provide credit history challenges because this person could be very new to the United States, not necessarily, but you could also follow up to request credit history if they're new, such as payment of phone, utilities, or rent wherever they did live. And also note that the ITIN does not provide work or legal status. It's really just a tax document for the IRS that helps these people establish residency, perhaps a driver's license, or pay taxes to establish citizenship. So the key here is to, whether you have your own internal application or you're using a vendor platform, confirm that is compliant for January 1st, 2020 coming up. Okay, construction delays. This is a very, very monumental, different provision that I believe is much broader than it sounds. So this new 504B153 refers to new construction. I think the average person might assume, well, that just means like a new ground up apartment building, Class A somewhere. And that does not apply to my 1960s building in Uptown or my 1970s building in Burnsville, whatever. However, as in law, details matter and you have to read the definition. And here they're referring to new building, rehabilitation, modification, reconstruction, any physical changes altering the use or occupancy of the dwelling units or in addition to a building, if the landlord's informed by the builder or otherwise knows that the new construction, which we just covered, for rental occupancy will not be available for occupancy by the move-in date established in the lease agreement, then landlord must, within 7 days and prior to the move-in date, notify every tenant affected and offer the following choices to the tenant, accepted at tenant's option. Again, super key language here. It's basically saying there's a menu choice and the tenant gets to decide, not the landlord, of equivalent alternative housing, a payment equivalent to rent, or termination of lease and return of all paid amounts. Okay. So we're going to go into more detail here. Equivalent alternative housing would be the size, amenities, and locations until the unit may be lawfully inhabited. So you're providing very similar type of a unit until the unit that's signed for the lease can be lawfully inhabited. Number 2, the payment equivalent of rent. You're basically paying their rent in the lease until the unit may be lawfully inhabited. And number 3, the lease termination and return all amounts paid, rent, deposit, and which is key here, other payments and entering the lease agreement. And that's what we're going to refer to here. If it's 1 or 2, the landlord must provide tenant with reimbursed security deposit, application fees, parking fees, pet fees, and any other fees. So if they have to reapply somewhere else and it's not their building, all of these are going to be in additional for the alternative housing. And then lastly, there's also another provision of even if they do take options 1 or 2, the tenant still may terminate the lease if the unit's not available for occupancy within 90 days of the lease, the move-in date. And so here's an example of a form where it's tied to the statute that basically says notice of unavailability of lease premises on move-in date due to new construction. And this would allow the tenant to understand it. It would also have the parties less likely to make an error about what's being communicated and what options are being selected. And that also will be on minnesotalandlordforms.com. Okay, common area covenant. So 504B16 has always been, not always, but for a long time, a statute in Minnesota that covers what the landlord has to covenant the leased premises for. And so now there's new language that the legislature expanded in 2024 that covers common area. So I'll just briefly refer to these. Keep all common areas in reasonable repair, including services and conditions listed in the statute, and extermination of insects, rodents, vermin, or other pests on the premises. Make all common areas reasonably energy and efficient, maintain premises and all common areas in compliance with local health and safety laws, including ordinances regulating rental licensing. So that's a new provision there as well. And they're referring to this 504B 380, that they're tying in these emergency loss of services as a landlord covenant. And so what's the practical impact of this new language? Well, as we mentioned, it refers to common area, but it all ties into what's a violation under statute at a property. And so, for instance, one option would be for a tenant to file a rent escrow action. This is if they've given notice of a, quote, violation, nothing's happened over 14 days, they deposit rent into court and bring a case against the landlord. Well, now it's not just leased premises, it also includes common area. So the common area outside of their door. And then obviously the tenant frits covenant of habitability as a defense to eviction action for non-payment of rent. They can refer to not just a violation of inside their unit. Let's say they have mice inside their unit. They can claim mice in the common area is a habitability issue and raise that as a defense to not wanting to pay rent as well. Those are a couple of examples. Okay, another major change that can't be understated how much this impacts landlords in Minnesota. And that is rental application eviction denial restrictions. Effectively, for those in Minneapolis who've managed your own buildings, you're familiar with the ordinance there that basically says landlords shall not deny rental applicants for any of the following on credit and criminal, etc. Similar type of a structure, but different and obviously now statewide. So the landlord cannot deny for any pending eviction action, right? So even if it's filed, even if it's public, if there's no final resolution, they can't deny. So if a tenant's being evicted out of where they're at and they're applied to your unit and there is no other reason to deny, but you see that eviction, because their proceeding is not complete, you cannot deny for that public eviction so long as it's prior to a final order. Okay, so a court file that's not public, expunged, or destroyed. So any of those reasons, if an eviction has been expunged, not public would mean confidential, meaning somehow they got a copy of it from another landlord. That's not a reason to deny. They're making it clear in the statute. Or this last one, any eviction action that not resulted in writ of recovery or premises and order to vacate. This is the largest one of the three right here. This means that any eviction action, let's say there was a breach of lease for non-payment of rent and they owed here's an example down here. Failed to pay $10,000, but they left before the landlord requested a writ of recovery. You can't use that eviction act against the tenant because there was no order to vacate, writ of recovery and order to vacate. Or, so let's say there was an unlawful holdover. Tenant stayed longer. There still was an eviction filed, but they left before the writ of recovery. No, you can't use that. Material breach of lease, like they destroyed the property. You can't use the information found in the eviction action as long as, again, there was no writ of recovery in order to vacate. If that information was obtained from a prior landlord, yes, that could be used separately. And again, all judgments for plaintiff landlord without a writ, no. You need the writ of recovery in order to vacate. Okay, so what does this mean? You'll have to modify your rental criteria, whether you're in Minneapolis or Minnesota, because you're going to be applying against those. So all that old eviction language is no longer valid as of January 1, 2025. So whether you're denied your criteria, your application denial letter, your application acceptance letter, all of that is going to need to be updated. And MinnesotaLandlordForms.com has all of those documents updated for January 1, 2025. The first one was Minnesota. Here's an example of Minneapolis, which also is complicated because you're combining Minnesota language with Minneapolis language. And so you actually end up needing a hybrid of the two to correctly apply them in January 1, 2020. So you're using Minnesota's, and then where Minneapolis is more restrictive, you have to apply Minneapolis as well as a second filter. Okay, this one is pretty straightforward. Late fees and housing assistance payment contracts, HAP contracts. For those of you we're familiar with Section 8. This is pretty familiar, and many landlords have been applying this standard for a long time. But 504B17, it really refers to that the late fee, just jump down here, must be calculated and assessed only on the portion of rent payable by the tenant. So if rent's $1,000 a month, the government pays $900, the agency, the tenant pays $100, the late fee would be $8 if there's an 8% late fee. So again, this would be applied monthly and one-time fees. Pretty straightforward. If you have questions, you're welcome to follow up. Okay, condemnation. This one is not going to apply all that often, but basically there's new language that refers to an order to vacate due to violations of a housing, health, or fire code or rental licensing ordinance. Essentially, basically making it a little bit more broad of what condemnation is allowed to occur, effectively not allowing the unit to be occupied. And again, note down below, this violates the covenants of the landlord. Okay, so mental health emergency calls and police calls. 504B205. For those of you who have been around quite a while or familiar with police calls, you're probably familiar with crime-free addendum and other specific language. And a common theme in the past has been if a tenant has a high number of police calls to the building, then that potentially could be used against the tenant to evict that tenant. What this new language does, it clarifies that the tenant has a right to call the police effectively in unlimited numbers if it's related to a mental health or health crisis. And similarly, that says the landlord can't impose a penalty on the tenant for calling for police or emergency assistance in response to domestic abuse or any other conduct, including but not limited to mental health or health crisis. Again, so make sure what does your lease language say on the crime-free addendum or how you're applying a breach of lease, because this will be an absolutely new language that your staff or property manager must know how to understand and implement correctly. And understand it says it preempts the local ordinance rule. So in some cases, you may have had city ordinances that refer to requiring landlords to take specific actions. This basically says, no, this new law would preempt any of the city's ordinances that might be more strict, that would force the landlord to do something or relate to fees imposed for not taking action. All right, victim of violence. Many of you may have known that there was new language added the prior year related to victim of violence. And really all this does is add new minor modifications to the existing victim of violence. From a high level, if you've never heard of it, the tenant to a residential lease may terminate the lease without penalty or liability if the tenant or another authorized occupant fears imminent violence, domestic abuse, criminal sexual conduct, sexual extortion, harassment, and they have to sign and date a written notice to the landlord. And there's language about the date on which the tenancy terminates. So there was just minor language about the date the lease will terminate, and it also allows new method of notice to the tenant. It can be a written communication, which is just how they regularly communicate with the landlord, and understand that there's pretty key language as it relates to, what happens to the other tenants, what happens to the security deposit, how long is rent continue to be due. All that is going to be under the statute. And it's also what we have a form here at Minnesota Landlord Forms, which allows the parties to check the box and clearly understand what happens to the tenancy, what happens to the security deposit, and also what happens in a single tenant or multiple tenant scenario. And then, so we also have, there's a victim of violence form. The state statute, also has what's called a qualified third-party statement, which we don't have here, but is also a form, and there's an acceptance or denial of victim of violence, and then lease termination. All right, so this last one relates more to property managers and process servers who have evictions. And from a high level, for a long time, process servers, let's say you had a larger building, a 10-unit building, a 100-unit building, the statute did not require them to actually go to the door. They could use the main number to call in, buzz the unit if no one was there. That was an attempt at the common area door, or post the eviction at that front door. So there's going to be additional requirements now, in addition to the prior eviction. So now there's a new 504B3. So first, the landlord must make a good faith attempt of electronic written communication at least 7 days before the hearing. So now the landlord as well needs to communicate to the tenant the same information that's in the summons that's being served to the tenant. And then it says that this just kind of gets into, use of email. How do you communicate to the tenant electronically? That's how this notice needs to be communicated as well. Could be a web portal, could be email, and that you need to communicate an eviction hearing has been scheduled, and the communication must have a time and date stamp, and then also talk about the information of the hearing. And then specifically, if there's, this gets into what I wrote, the main change I talked about before, which is in the past, they could just post at the entry. Now it says, on the service component, if the personal or substitute service is unsuccessful, meaning the tenant doesn't answer the door from the process server 2 times, then yes, you need to service mail and posting, but the posting needs to be by the entry to the tenant's individual unit, on the door of the individual unit. So it's basically saying the process server needs to get in. So you're going to need to have property management be available to let these folks in, or the process server has access to the lockbox that gets them into a common area door and posts on the door. As well, with mail and posting new affidavit statements that the process server needs to state the day and time of the service attempts, as well as the day and time of the posting to the unit door, as well as checking the box that this new electronic communication compliance occurred. So the affidavits have to be new as well. Okay, so here's a form that can be used by landlords that MinnesotaLandlordForms.com has for notice of an eviction hearing. This would comply with the new statute. All right. A lot of material, super dense. We look forward to everyone in our coming up launch of Minnesota Landlord Forms in December 2024. Thank you for following us all the way to this lesson. If you haven't already, you can visit MinnesotaLandlordForms.com to register for the waitlist. And again, I'm Bradley M. Schaeppi with Minnesota Landlord Law. Again, note, this was not legal advice. Thank you very much. Have a great day.